Why there is no respect to the court orders?
Lord, every night he keeps sending emails. After hearing before your lordship, he says you're going to go to court, you do what you want, I'm not scared. Lord, these are payments made by the mother directly to the school.
But where?
Lord, my learned friend I think is it's trying to deflect the issue. Your
lordship. No, I am not. My lord, on the previous date of hearing, a clarification was sought with regard to documents that have been filed by the respondent. I would like to make those clarifications. So, first and foremost, document number 1 and document number 3 are already a matter of record in the assets and liabilities. They are not a fresh document that has been filed. So, let's take these documents head on. One statement that has been made in document number 5 is that there is a bonus that has been paid in the month of May 2024. This, according to the respondent, is an anomaly. It most certainly is an anomaly. It's a bonus and it's variable pay. Therefore, it does not form a part of the salary statement. Doubling down on this, in document number 3, which is on page number 3 provided by the respondent, they have highlighted before this court that the CTC is 25,80,004. That's correct. But if one turns the page, my lord, one sees the breakdown of the CTC. In that, we see there are deductions with regard to Provident Fund, something that's not part of salary. Next, we have notional value for insurance premium, again not counted as part of salary. Variable pay is not part of salary. When these figures are deducted in a given month, the amount that comes is 1,21,000 odd rupees, which is the figure that has been put forth as the salary of the petitioner herein. And then I would like to also look at document number 4, my lord. Document number 4 has been listed as the payments that have been made by the respondent towards Master Ayansh's school fees. I'm not able to decipher this document, my lord, because it says a certain amount of money has been paid by Ayansh Rathore. This, where has it been paid towards the school? There's no context to this document. I do not understand it.
Mr. Gondiraj, what is this file?
Lord, these are payments made by the mother directly to the school.
But where?
Lord, my learned friend I think it's trying to deflect the issue. Your
lordship. No, I am not. Sorry. And I will explain why.
Kindly allow me to make my submission.
No, don't misrepresent what I'm trying to say, sir. I am asking a very simple question, my lord. It says that these are amounts that are to be paid to the school. This is a financial transaction. Where is the school's name in this, my lord?
Well, the question before the court the other day was, an affidavit is filed before the family court declaring the take-home salary as 1,21,000.
That's correct.
While the petitioner had a document in his hand which said his salary was 2,15,000 rupees a month.
It's
No. Now you have heard what is his submission
Yes.
with regard to 2,15,000. What do you say on that? He says the basic salary is 75,250. Allowance that is flexible is 93,267. He shows 16. Then after that, after Provident Fund, gratuity, everything is
14,000. Deduction is 14,000. Subtotal B is 14,000. Apart from that, variable pay is 32,250. Total is 2,15,000.
Yes, because it adds C.
May I make this request, my lord? 31st of July is when the affidavit of assets and liabilities is filed. My learned friend has not filed the salary certificate for 31st of July. It's only filed for April, May, June. If he files a salary for July and August, my lord, your lordship, it will become, we'll be aware, my lord, how much he has received.
On the contrary, my lord, they have said gross CTC is A plus B plus C at the bottom of the table. It is my submission before this honorable court that C cannot be considered.
No, instead of complicating all this.
Yes, my lord.
You have your July and August, June and July, your salary slip must be there.
I can procure it. It's not.
You can place it.
Yes.
So we don't have to go into the other issue.
I understand, my lord. My lord, I would also just like to put forward one simple point. The rationale that has been used by the lower court for passing this particular order, which is being challenged now before this court, which was the grant of 25,000 rupees to the child as well as 20,000 rupees towards litigation costs. Now, the rationale that was used was that both the petitioner and the respondent earned roughly the same salary. Now, the difference between them is give or take of 30,000 to 38,000 rupees in salary. One is about, I am about
You have
1.21.
questioned that order.
Right. I'm questioning the maintenance, but I'm trying to understand the rationale of the court in order to just put forward why I am going into the nitty-gritties. I earn 1.21 lakhs. They earn about 1.6 lakhs. Now, normally, if I earn 30,000 rupees and he earns 60,000 rupees, the rationale of the trial court will not be that we earn the same amount of money. The difference between the two is about the same, between 1.2 to 1.6, and say 40,000 to 60,000, or 30,000, 60,000, it's about 30,000 rupees difference. The reason being that there is a threshold in society that exists. When you earn about 1 lakh more, you are earning a lot more than the general public that exists in this
Not
country.
going to all that.
No, so the
No,
reason being,
let's not go into all those ratios. Let
All
me
right.
tell you. Now, you are earning 1,25,000, as you say, and the wife's salary is 1 lakh.
Yes,
Then
ma'am.
the son is with the wife, who has
That-
to take care of his needs.
yes, my lord.
So irrespective of what it is,
Yes.
you are like with your salary, you can contribute what the court has given.
Absolutely, ma'am. But I have one counter submission to that, my lord, in that the liberty is given now to the particular person who's in custody of the child to come up with an estimate of the costs of the child. This is understandable. Every father must also contribute to the taking care of the child. But that does not give leeway to create inflation of costs. It is a submission before this honorable court that I believe the total amount.
Come to the impugn order.
Yes, ma'am. So the governing rationale over here is that there's some rough parity between the two parents. Therefore, the two parents should equally bear the costs of the child. What is the contention of the petitioner is that while that's absolutely true, it is the contention of petitioner respondent has inflated the cost of the child, and it does not come up to
What is his
50,000.
age?
His age right now, why am I?
He's 8 years old.
Yes,
Turns 8 next month.
He's turned 8.
What is his school expenses?
2 lakhs, my lord, is the school fee.
Yes.
Yes,
If it is 2 lakh per month, per year,
Yes.
how much it comes to per month?
per month will be 2 divided by 12, so let's say it's 10, so it's 20,000. 20,000, we're adding about another thing is give or take, it would be come up to about 21,500, my lord. No, it's a little more.
16,666.
No, how, just for
It would
2
be
lakhs?
less, not more. It would be 16,000.
No,
16 to
no.
18,000.
What I'm saying is that the cumulative amount that has to be paid with everything else.
No. We are only on the educational expenses.
Oh, just the education
So
is
educational
60,000.
expenses,
Yes, ma'am.
16,000 and odd is coming. And where are they residing?
They are here in.
They're not residing
They're
in
not,
any,
no.
they're residing in a rented premise. Then both the child and the wife are residing.
Yes, that's correct.
Then for him, there are other several expenses.
That's
which
correct,
are-
ma'am. Yes.
In my view, the court had rightly granted, because the court has not given any other educational expenses. Extra educational expenses, everything is amounting to 25,000.
It is also we would like to submit that also 8,000 rupees is being given towards a premium for future educational expenses, which has been.
How it will meet his day-to-day expenses? What
Yes,
is it going to come after 18 years?
Yes, my lord, that is true. The 8,000 rupees doesn't go towards the payment of current expenses, but it is for future educational expenses, and it is an amount the father is indeed paying for the child. And it is something that is coming out of the father's bank account every month towards the education of the child.
But nobody is asking you to pay that. That's your choice you have made.
Yes, but it is towards educational expenses. I would just like to put forward that where even though it has been postponed to a period of time when the child become post 18, it is towards educational
come.
expenses. I would also just like to highlight one more thing before this thing. In the assets and liabilities of the respondent, for the year 2020 and 21, they have deducted house allowance in their income tax. But they cohabited till 2023 April. It's just a point I would like to put forward that rent was not paid, but house allowance has been deducted for 2 years while she cohabited with the petitioner. This is just one point I wanted to put forward.
Agreed with orders.
But I have only one request. On the last occasion, document number 7, I brought to the court's notice, undertaking given by the petitioner before the family court. He will stop sending emails to the respondent wife. Not every night he keeps sending emails. After the hearing before your lordship on 2nd of July, another email at 11:30 in the night, not he sends. After hearing before your lordship, he says you're going to go to court, you do what you want, I'm not scared.
Why there is no respect to the court orders from your client? Why is he doing all this? Give it to him.
I'll place it on record with a copy, sir.
I do not know how I can be a drunkard.
At 11:30 in the night, my lord, same night, on 2nd of July.
Why he feels like communicating after only 11 o'clock?
All communications after 10 p.m. And it goes on till 1 o'clock, 2 in the morning.
Please let me talk to my client, my lord.
Undertaking given to the court.
Talk to him and I'll pass orders on this tomorrow.
Yeah.
Tell him that this is not the way
Yes.
he'll go ahead.
Sure.
If they're not liking each other or if they want to be separated, whatever it is, there is a way. All educated people, this is not the way you go.
I agree, my lord. My lord,
Find
but
a lady like this.
my lord, I would also like to highlight that there is an order for visitation rights. My client has not got any opportunity to visit the child.
I'm sorry.
This is what is
We
happening.
have been complying with the visitation. When he said, I'm not going to pay maintenance, she said, until you comply with the court order, I will not comply with the court. You comply with the court order, I will comply. Visitation was being extended every week. He says, I will not pay maintenance. Yes.
As you know, this is a chain reaction. Husband does something, the counter, the wife will do, again, husband will do something else, and they'll be, in this cycle, they'll be going on. And there is no end to their problems. Somebody has to be wise enough to, please talk to your client,
I
come
will.
back, tomorrow I'll pass orders.
All
Then
right.
this also for judgment in the talk tomorrow.
Bless.
Much obliged.
एक बच्चे को माता पिता दोनों का प्यार चाहिए होता है, लेकिन आज के दौर में जब तलाक हो जाता है तो उस प्यार और देखभाल के बीच भी एक रेखा खिंच जाती है। कर्नाटक हाई कोर्ट की इस कार्यवाही में पति ने एक याचिका दाखिल की है जिसमें वो मेंटेनेंस की राशि को कम करने की मांग कर रहे हैं और यह भी चाहते हैं कि वो अपने बेटे से बिना किसी हस्तक्षेप के मिल सके। दोनों माता पिता की आय लगभग बराबर है, जिससे दोनों मिलकर बच्चे की देखभाल बराबरी से कर सकते हैं, लेकिन पति इस बात से सहमत नहीं है। बहस के अंत में पत्नी के वकील ने एक दस्तावेज कोर्ट में पेश किया जिसमें यह दिखाया गया कि हर बार सुनवाई के बाद पति ईमेल पर लड़ाई करता है और साफ कहता है कि कोर्ट के आदेशों को वो नहीं मानेगा, जो करना है कर लो। फिलहाल के लिए बस इतना ही, जल्द मिलेंगे इस मामले की अगली जानकारी के साथ। धन्यवाद।